The right to criticize political leaders and governmental officials is a fundamental principle of democratic government. It helps keep officials from abusing power. It helps inform citizens so that they can go to the polls and vote for candidates who best represent their views. It provides a check, perhaps an essential one, on government power. But what if the press prints falsehoods? What if it prints lies that unfairly hurt a person's reputation? What if it sets out to destroy a candidate or an office holder? Should it have a protected constitutional right to do these things? Does it? These are the issues the Supreme Court addressed in 1964 in New York Times v. Sullivan. But before discussing the case, we need to recall a bit of background. The First Amendment to the United States Constitution states in part, "Congress shall make no law abridging the freedom of speech or of the press." Now, despite this language about no law, the Supreme Court has never interpreted the First Amendment literally. For example, we can't publish material that gives away state secrets. We can't publish the location of troop ships in a war. We can't publish material that leads to committing fraud. But can we publish material critical of the government and governmental officials? In the 18th century, when the U.S. Constitution was drafted, the answer was generally no. The accepted practice dealing with speech critical of the government came under the doctrine of seditious libel. And seditious libel made it a crime to criticize the government, regardless of one's intent or even the truth of the criticism. Criticism of the government, even if truthful and correct, could be punished. The notion here was that criticism weakened the government. By 1776, however, Sir William Blackstone, the great commentator on the British common law, had concluded that freedom of the press meant there could be no prior restraint on publication. This meant that people had a right to publish what they wished, but that they could be punished for it afterwards. This is what Blackstone wrote. "Liberty of the press consists in laying no previous restraints upon publications." But he continued, if a person publishes what is improper, mischievous, or illegal, he must take the consequences. In other words, although publication couldn't be stopped because it criticized the government, its authors could be arrested and prosecuted if the laws called for it. Now, this understanding of the First Amendment was confirmed by Justice Holmes of the U.S. Supreme Court as late as 1907. Note, too, that the words of the First Amendment are addressed to the Congress, not the states. Under the U.S. Constitution, the states were free to treat publications however they wished, constrained only by whatever limitations were contained in their own state constitution. This changed with the doctrine of incorporation, through which the court used the 14th Amendment to apply almost all of the Bill of Rights to the states. The First Amendment, for example, was held applicable to the states in 1931. Now, the Sullivan case grew out of the civil rights movement in the South in the 1960s. In February of 1960, a student-led sit-in movement had started in which African-American students sat down at lunch counters to protest racial segregation, and they refused to leave until they were served. On March 29, 1960, a full-page advertisement appeared in the New York Times. It was called "Heed Their Rising Voices," and the ad was signed by 64 members of the clergy as well as other people of prominence. The ad complained that the police in Montgomery, Alabama had ringed the campus of Alabama State College and had padlocked the dining hall in order to intimidate the protesters, that Dr. Martin Luther King had been arrested 7 times, and that acts of violence had been directed at the protesters. It appealed for funds to support the student movement, the struggle for the right to vote, and the legal defense of Dr. King. In response to this ad, L.B. Sullivan, who was one of 3 white elected city commissioners of Montgomery, Alabama, sued the New York Times for libel, the printing of falsehoods. Although he was never mentioned by name in the ad, he maintained that the words "police" in the ad referred to him, since he was the commissioner who supervised the Montgomery Police Department. And it turned out the ad contained some factual errors. The police had not ringed the campus, and Dr. King had only been arrested 4 times, not 7. In addition, in one place, the ad alleged that the protesting students had sang "My Country 'Tis of Thee" on the state capitol steps when they had actually sung the national anthem. However, an all-white jury found the New York Times guilty of libel for publishing the ad and awarded $500,000 to Sullivan in damages. The New York Times appealed. $500,000 was a fortune in 1964, even for the New York Times. The lawsuit was part of an effort by the white leadership in Montgomery to destroy the civil rights movement. If the verdict was upheld, the New York Times and other newspapers and media outlets might be forced to stop accepting ads from civil rights groups, depriving the civil rights movement of a valuable fundraising tool. However, the Supreme Court overturned the libel verdict in a unanimous decision. Justice Brennan wrote the opinion, and early on he wrote the following: "We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials." He dismissed the mistakes in the ad, noting that constitutional protection didn't depend upon the truth or the popularity or the social utility of the ideas and beliefs which were expressed. The court was particularly worried that requiring truth as a defense would lead to what it called self-censorship. If the verdict was upheld, Brennan wrote, people would not feel free to criticize government. This is what he said for the court: "The pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive." Now, did this mean that all libel law was unconstitutional? No, it didn't. It did mean that for a public official to prove libel, the Constitution imposed a strict three-part standard. The standard was this: in order for a public official to win a libel suit, he had to prove that the statement made was, first, a defamatory falsehood, second, that it related to his official conduct, and third, and most importantly, that it was made with actual malice, meaning with knowledge that it was false or with reckless disregard for whether it was false or not. Now, in concurring opinions, Justices Black, Douglas, and Goldberg argued that the Supreme Court hadn't gone far enough in protecting the press. For example, Justices Black and Douglas argued that the New York Times had a, quote, absolute, unconditional constitutional right to publish the advertisement. Now, the Sullivan standard of actual malice makes it very difficult for public officials to win libel suits against the press. It grants the press a great deal of legal protection for criticism of governmental officials. Although the language of the decision is really quite sweeping, one might wonder how much it matters. Many other democratic countries don't afford the press such constitutional protections, yet have robust political criticism. Further, it appears that the American people don't share the justices' passion for protecting the press. Even a decade and a half after the decision, when Gallup asked if the present curbs placed on the press are too strict or not strict enough, nearly twice as many respondents said the restrictions were not strict enough than said they were too strict. And it turned out one of the three main reasons respondents gave for wanting stricter curbs placed on the press was that newspapers published information that respondents said should not be made public because it is not in the best interests of the nation. Although the legal right exists, in practice the freedom of the press to criticize the government depends upon public support. The press depends upon the public for its livelihood, and without its financial support, its freedom of expression is constrained.